Good afternoon and welcome. Firstly, a quick apology. We are running slightly behind time, but we are on now. So, quick introduction. My name's Fig Kakar. I'm the Vice President for APAC at Open Table. Today we're going to follow on to the second part of our webcast live series. The last one we conducted was navigating your business through the face of uncertainty, and we had a great response back from the people who joined us on that, which compelled us to do follow-on sessions. Today, we're going to look at how to navigate your business through the government stimulus package, better understand how you can take advantage of what's applicable to your businesses, and how and where you can find this information. The steps that you can take will basically determine on your own business needs. One thing I do want to highlight through this session is that the information that we provide is for information purposes only. The information that's provided is not any kind of guidance or advice on anyone's particular business. So I just want to make sure that everyone keeps that in mind. To help us better understand these key fundamentals of taking advantage of the government stimulus packages and how to help each businesses, we've been very fortunate to have the team and our partners from KPMG, and I'm going to introduce them shortly, who will basically run the most part of this session. So with that, I'd like to welcome Andy, Jenny, Huda, and Kenny, who are all online right now. And I'm going to pass it over to Jenny to kick off this session. So Jenny, over to you.
Yeah, thank you very much. So I'm going to go through two aspects at the moment: the current status of the JobKeeper rules, and also how does an employer qualify for JobKeeper, before handing over to Andy, who will talk about who is an eligible employee and what employers should do. So the Australian government first announced a JobKeeper subsidy on the 30th of March, and we received more just before Easter long weekend on the 9th of April. In between, you can see on one of the slides that there's been various updates along the way to develop the principles of the new law. Now, it's important to note that the legislation we got on the 9th of April is probably not the last lot of JobKeeper material we will see. The Commissioner of Taxation or the Australian Tax Office is the relevant decision maker with respect to the entity's entitlement to the JobKeeper payments. So I would expect to see more guidance from the Tax Office, but we do have the main rules which we will go through today. The first thing I will cover off is how does an employer qualify for the JobKeeper scheme? Just trying to see if I can move on to that slide. Okay. So it's important to note that the JobKeeper scheme is a temporary measure. It's designed to help businesses, including restaurants and cafes, to retain staff and continue to pay them despite a fall in their turnover during the shutdown period. Now, the JobKeeper scheme will help you with your cash flow, essentially, so that when your business starts up again, when the lockdown is lifted, you can scale up your operations quickly again without the need to rehire when the downturn is over. Now, for an employer, there are 6 key criteria you need to satisfy to qualify for the JobKeeper scheme. The first is the employer must carry on a business in Australia, and I expect most restaurants and cafes businesses operating here in Australia will satisfy this condition. The second is the employer must satisfy the decline in turnover tests at a time during the JobKeeper fortnight, and essentially this includes like 13 fortnights from the period of 30th March to the 27th of September 2020. Now, some points to note here is that the decline in turnover tests distinguishes between small and large businesses. So if you're a small business, then you need to demonstrate you've had a 30% decline in your turnover in order for you to get the JobKeeper. If you're a large business, you need to demonstrate a 50% drop in turnover. Another important point is that once you demonstrate a drop of turnover once, you don't need to keep testing. If you don't qualify for April, for example, but there is a drop in turnover in May of at least, say, 30%, then you qualify for JobKeeper from May onwards. And I'll speak a bit more about the turnover test. The third point third criteria you need to satisfy, the employer must have paid wages equal or exceeding $1,500. Sorry, the employer must have paid wages equal or exceed $1,500 per fortnight to an eligible employee. So it is important to note that $1,500 must be paid regardless of whether the employee ordinarily receives more or less than this amount. So if an employee ordinarily gets greater than or equal to $1,500 per fortnight, then they will continue to receive their regular income under the workplace arrangements. JobKeeper payment will essentially subsidise the employer for $1,500 per fortnight. If the employee ordinarily gets less than $1,500 per fortnight before tax, then the employer must pay at least $1,500 per fortnight. If the employee stood down, then the employer must pay the employee at least $1,500 a fortnight. And if the employee was employed as at 1 March, ceased employment, and then rehired, the employer must also pay the employee at least $1,500 per fortnight. The fourth requirement for the employer is that the employer must notify the commissioner that they elect to participate by the end of the fortnight, except for the first fortnight, which ended on the 12th of April. For April, the employers have until the 26th of April 2020 to provide the commissioner an election that they want to participate in the JobKeeper scheme. Now, there's no details yet on how this election is made. All we know is it must be in an approved form, which is likely to be a form that the tax office wants you to fill in, want the employers to fill in. But employers need to register their interest on the ATO website. The fifth criteria the employer needs to satisfy is that the employer must give information to the commissioner on the employee's eligibility. So it's anticipated the commissioner will want details such as the name of the employee's employment status, the employee's citizenship, residency status. And if the information doesn't change, the employer is not expected to provide the information to the commissioner again. But if the employee no longer is eligible, then there is an obligation to tell the commissioner. And the final condition is that the employer must not be excluded from the scheme. And this essentially is the banks, government agencies or wholly owned entities, or a company where liquidator or provisional liquidator or trustee in bankruptcy. So just moving on to talking about the decline in turnover. Okay. So I mentioned earlier that one of the key conditions for an employer to qualify for the JobKeeper scheme is that the employer must have a decline in turnover. And your percentage decline must be at least 30% if you're a small or medium business. And if you're a large business, then you must demonstrate you've had at least a 50% decline in turnover. So essentially a large business needs to demonstrate a greater decline in turnover than a smaller business. Now, how do you determine if you're large or small? So that depends on your aggregated turnover, which links into what's called your connected and affiliated income, and it can include foreign income. And it's the higher of the current year or the previous year amounts. If you're a small entity, if your aggregate turnover is less than $1 billion, but you're large if your aggregated turnover is more than $1 billion. Now, the mechanics of measuring decline in turnover is that you take your GST turnover for the 2020 month or the quarter, which is generally aligned with your BAS reporting periods, and compare that with the equivalent period in 2019. So if there's a drop by 30% when comparing your turnover in those two periods, assuming you're small, then you pass the test. So for example, come the end of April, you're comparing your turnover for the month of April 2020, with April 2019. To see if there's a 30% drop in your turnover to satisfy this decline in turnover test. And if there is a 30% drop, you satisfy this condition to meet the JobKeeper subsidy. Now, if you don't have a comparable period in 2019 because you're in a startup phase or there was a business acquisition, you may pass the test because of the Commissioner's discretion under an alternative test. So on that note, I will hand over to Andy to talk about which employees can get the JobKeeper.
Thanks, Jenny. Now, the key thing about eligible employees is that they have to have been on your books as a staff member at the 1st of March 2020. If they weren't employed by you on the 1st of March 2020, then they are not eligible to be part of this program. The other eligibility requirements are that the employees are aged 16 or over, that they've either been a full-time or part-time employee, or if they are a casual, that they've had at least 12 months regular and systematic work with your business, and then you can claim for that casual as well. Importantly, eligible employees only includes Australian citizens and permanent residents, and most New Zealanders. So folks who you've employed on a temporary visa of some kind generally would not be eligible. Now, you are required to nominate the employees to the tax office who are eligible, and you're also required to get the employees, first of all, consent, and secondly, confirmation that they meet those eligibility requirements that I've described. So there's going to be a process here where you need to tell your employees that you're intending to take part in the scheme. You need to get a confirmation from them that they're eligible and that they want to be part of the scheme. And then you need to confirm back to them as an employer that you are in fact participating in the scheme and you are going to pay them the required $1,500 a fortnight. Just also be aware that anyone who's on a government parental leave scheme or dad and partner pay, or who is getting workers' compensation because they're completely unable to work, those people are not eligible either. There's also the ability for organisations to participate in relation to someone who is not an employee. So that's a business which maybe is a sole trader, or where the principal of the business is just in receipt of trust distributions or dividends rather than a wage. And so each business can claim in respect of just one such person for the JobKeeper period, provided that they meet the same criteria otherwise that an employee would have to. So if you've got a business that's remunerating an individual in that way, then that one person per business can also be eligible in addition to applying MBAs. So just to sum up, what do you need to do in relation to JobKeeper at this stage? Firstly, I'd encourage everyone to register on the ATO website, and that will make sure that as more details become available about the admin processes that the ATO is going to require, you'll get that information straight away. Once you've registered, have a think about which one of the turnover decline thresholds is going to apply to you based on the kind of business that you are. And then have a think about what your turnover is for starters, March or April 2020, and comparing that to the March and April 2019 turnover in terms of whether your business is going to qualify under the basic condition. Noting that the Commissioner may well bring out some modified qualifying criteria for certain types of business if the comparison to 12 months ago is not thought to be a fair one. Once you've applied to the Commissioner, you need to send the notice, as I mentioned, to the employee, getting their consent to participate and their confirmation that they're eligible. And then for every fortnight, you'll need to keep updating the Commissioner on your participation and your eligible staff. Now, a lot of that work will be done through the single touch payroll process, so it should be able to be pre-populated in a lot of cases by the ATO. And then you also need to make sure that your employee is kept up to date on the fact that you're continuing to to nominate for the JobKeeper. So there's a number of admin steps. We're expecting that the ATO will put out some communication reasonably soon that will set out exactly how it imagines these admin steps will work. And if you do register your interest at the ATO website, you will get those communications as soon as possible. That's a wrap on JobKeeper. I'm sure we'll have a bit of time for questions at the end. I'll now pass on to Huda and Kenny, who will take you through some of the other things that you need to know in relation to government support for business.
Thanks, Andy. Hi, it's Kenny Chen from KPMG Law. In addition to the JobKeeper payment scheme, which Jenny and Andy talk about, Huda and myself are thinking it's a good idea to also give you some brief overview in terms of the temporary relief measures that are available for companies and individuals who are suffering from financial distress due to the coronavirus. So on 23 March, the government issued temporary relief for financially distressed businesses, aiming to prevent unnecessary insolvencies arising from business closures due to COVID-19. Briefly, these measures make it harder for creditors to take actions against the businesses during this crisis time. And it also gives businesses and its directors who are experiencing financial distress to have some reprieves and essentially more time to consider their options. It is worth mentioning that from the outset, those measures are not like a lot of the tax measures that had been enacted, where you need to make an application to the ATO. Instead, those measures are already effective and apply across the industry. There are three key elements to these measures. The first one relates to the companies. Under the current Corporations Act, any creditor can issue a statutory demand on a company if the debt outstanding by that company is $2,000 or more. The company then has 21 days to respond to that statutory demand. Not responding to a statutory demand within the specified time would result in a presumption that the company is insolvent. Specifically under the law says that if a company does not respond to a statutory demand or is unable to comply with it, for instance, if it cannot pay the debt within the 21 days required under the statutory demand, then the creditor can apply to the court to seek to wind up the company in insolvency. The temporary relief measures that has been provided by the government for these purposes are to increase the threshold for creditors to be able to issue a statutory demand on a company. This has increased from $2,000 to $20,000, and the time frame for a company to respond to a statutory demand has also been extended significantly from 21 days originally to now 6 months. We see this as a very welcomed relief, as a creditor issuing a statutory demand on a company is almost the most common way for companies to enter into liquidations. In relation to individuals, under the Bankruptcy Act, a creditor can initiate bankruptcy proceedings against an individual if that individual owes $5,000 or more. Similarly, the individual then has 21 days to respond to that bankruptcy notice in relation to the debt that is outstanding. Again, not responding to a bankruptcy notice within the period is the most common act of bankruptcy for individuals. Similarly, the government also granted temporary relief measures that have been provided to increase the threshold for creditors to be able to issue a bankruptcy notice on an individual from $5,000 to $20,000 again, and again, the time frame for an individual to respond to the bankruptcy notice has also been extended from 21 days to 6 months. This will certainly help each individual to consider repayment options with the aim of arranging finance and so on. Before we continue, I think it is important just to clarify on what debt is regarded outstanding. For both companies and individuals, a debt is outstanding at the time it is due and payable, but it remains unpaid. It is then that a creditor can issue a statutory demand on a company and a bankruptcy notice on an individual. The third element of the temporary relief measures relates to debtor-initiated bankruptcy. Generally, when an individual or a company declares an intention to enter into voluntary bankruptcy, there's a period of protection when unsecured creditors cannot take further action to recover their individual debts. This period used to be 21 days, but with the temporary relief granted by the government, it again has been extended to 6 months. This will certainly provide more time for those debtors to consider their options. Lastly, I just wanted to mention that all of the temporary relief measures I have just discussed will apply for 6 months. Hopefully, this would see us through the COVID-19 restrictions. I will now hand over to Huda to talk about directors' duties in connection with insolvent trading.
Thanks so much, Kenny. That was great. So related to everything that Kenny just said is a core statutory duties for directors not to ensure that the company does not trade whilst it's insolvent. So this applies to directors of any type of company, be it proprietary limited, even with one shareholder, one director, public and public listed companies. All these directors on these companies have the same core statutory duties. So in relation to the duty not to trade while insolvent, the law specifically says that the duty applies to you if you are a director of a company at the time when the company incurs a debt and the company is insolvent at that time or becomes insolvent by incurring that debt. And at that time, there are reasonable grounds for suspecting the company is insolvent or would become insolvent because of the incurring of that debt. This is a personal liability that each director bears. And so the temporary relief measures that the government have introduced is actually a relief from this personal liability for each director in respect of any debts incurred in the ordinary course of business. And so the way that the relief will operate is that basically you will not be breaching your director's duty to prevent insolvent trading if the debt is incurred in the ordinary course of the company's business during the 6-month period starting from the 25th of March 2020, so just be mindful of that date, and before any appointment during the period of an administrator or liquidator of the company. So the purpose of this relief is to make sure that directors and the company itself can continue to trade during this period. And as Kenny pointed out, all of the previous measures, the relief is applicable for 6 months, and so is this relief. So it's all obviously related. So just to keep in mind, the relief provided is in respect of debts incurred in the ordinary course of business. So the government makes it clear that where you do incur debts and there's some suspicion of dishonesty or fraud, then you could very likely be subject to penalties. And in the worst case scenario, criminal penalties. And there's no point about talking about that now. That's not the purpose of this. But basically, as long as the debt you're incurring is in your regular course of business, there's absolutely no issue with you relying on this relief. It's important to just finally note that anyone who wishes to rely on this relief bears the evidential proof of basically proving that the company did in fact incur the debt in the ordinary course of business and in the relevant period I just mentioned. For this reason, it's really important to ensure that your company keeps its books and records in order so that you're documenting all debt incurred, the amount of the debt incurred, and the purpose and the timing of that debt. And under the law, there's actually a statutory requirement that companies generally keep their books in order. But I think if they are not in order at this time, then it's a really good time to be vigilant with that requirement. So finally, this relief does not override or put aside each of the other directors' duties that each director personally wears. All of those other directors' duties, for example, to act in the best interests to act with care and diligence and so on, they all still apply. And when I'm talking to boards and directors of any size company, the best way to show that you've thought about an issue and that you've basically effectively discharged your duty is to show somewhere where you've resolved on that decision. And the best way to do that is to basically have some form of resolution that talks about any material decision making that the company has basically moved forward with. And so that's part of keeping your corporate records in check. So where the board, and I appreciate some companies on this webinar only have one director, it's still applicable to you. The best way to show that you've made any kind of material decision is to basically have a board resolution to say the company considered this, the director resolved this, and then that's kept on your corporate file. And that really serves as proof of your decision making throughout this process. And that's it from me. Thank you very much.
Okay, thank you, guys. So, look, I guess the key here is of the two separate discussion points is, with Andy and Jenny, we're really talking and referring to the benefits that the government has provided to help small to medium-sized businesses continue trading and stay afloat through these very difficult times. And by all means, every business should be taking advantage of what the government is offering there, whether it be small or large. I'm certain that with many family businesses, any kind of funding and revenue assistance will absolutely help in staying open, keeping the doors open, and keeping people employed. And hopefully, we'll see this thing come out sooner rather than later, which will obviously preserve a lot of businesses and the economy overall. Second part that we spoke about was through Hoda and Kenny was regarding insolvency. Unfortunately, there are going to be businesses that do face this in these challenging times, and for anyone that is staring down that tunnel. I'm sure it's a very difficult situation and a difficult decision that you do need to make, but I hope that some of that advice and some of that direction that's been provided will give you direction on how to act responsibly. I think the biggest key takeaway out of this is, one, obviously take advantage of all the information and the help that's available at hand, but secondly, as was noted by our guest speakers 2 weeks ago in our last webcast, is make sure that you've got a good accountant that's able to give you the best advice on your own business. That is really important because every business has got their own niches and own requirements. So please don't just rely on general information and to make your own decisions. Invest into a good accountant that can help you. And I'm sure the guys from KPMG, for those that are interested, will be available to talk on how they might be able to help your business for our audience that's listening out there at the moment. So we are going to move on to some quick Q&As right now. And I'm going to start off. We've got a few here to get through, and I think we do have time. So hopefully we should be able to get through all of them. So question one to the team. If we nominate staff to be part of JobKeeper, can we ask them to work some nominal hours which would keep their earnings under the $750 a week with social distancing and safe practices in place? Can they refuse, and under what grounds? If they refuse, can you not include them in the JobKeeper program? So I'm guessing that's going to Andy or Jenny.
Yeah, it's Andy. I'll answer that.
Thanks, Andy.
So to be eligible for JobKeeper, the employee could be working the same hours as they ordinarily work. They could be working fewer hours than they ordinarily work if you've legally agreed with them that that can happen, or they could be legally stood down and not working at all, but still technically employed by you. So in terms of what you negotiate with your employees in terms of the working hours and so on, that would just need to comply with the employment agreement of whatever type that they were working under. You have to apply for JobKeeper for everyone who's eligible. So if you've got 2 employees and you say to them both, look, I'd quite like you to do a bit of work here, and one says, yep, that's fine, and the other says no, that won't work, and that's that's their legal right to do so, and you still retain them as an employee, then you can't just choose to claim for the one who worked, agree to work. You have to claim for both, and you have to pass the money on to both. So obviously, if someone says they won't work, then you need to think through what your options are in terms of whether you retain that individual on the books, subject to what your legal options are there. But you can't pick and choose between your eligible employees as to who you claim JobKeeper for. You have to claim it for everyone who is eligible and who says that they are happy to be a part of the scheme.
Great, thanks, Andy. Okay, second question. This one's from Rod. My business, which closed on the 23rd of March, was 15% down from this March 2020 against March 2019. Will I be eligible for a JobKeeper from March 30, or should I hold off until the end of April 2020?
So what to claim, to be eligible, you need to be able to show that your turnover was down by generally, if you're a trading business, at least 30% compared to the comparable period a year ago, and it has to be a period of at least a month. So you need to take a period of at least a month. The first month you can take is March 2020, and compare that to March 2019. If you weren't down by 30% for the whole of March, then you can test again for April, and then any so-called JobKeeper fortnight that falls within April, and for any fortnight thereafter, if you meet the test for April, then you would be eligible for those fortnights.
Right. So basically, because this one's reporting at 15%, they won't be eligible for the month of March. But once April closes, if they can prove and show that it was 30% or greater, then the JobKeeper would kick in from the month of April. Is that right?
Yeah, and you don't have to wait till the end of April. What you should actually do is say, right, I'm sitting here in April, and my reasonable, if you can document a reasonable expectation based on everything you would know, that you're going to be down by more than 30% for April, then you don't need to wait until after the end of the month to claim. Okay.
I think this next one is similar to this one. Just let me know if it's a repeat and we can move on. I own a restaurant. For the month of March, we have a downturn of sale of 26%, not 30%. As we were only really closed 1 week, we have now been closed for 3 weeks. Would we qualify for JobKeeper?
Well, again, it's the same. So you need to assess the situation on a monthly basis. So you need to look at what you think your turnover for April 2020 is going to be, compare that to April 2019, and there's your answer. Yep.
Great. Okay. Right. Question 4. If a venue is closed and not operating, in what capacity do we keep the staff employed?
Oh, look, that's an employment law question. You need to get some employment law advice in terms of what legal standing you would have in terms of keeping people on the books, but not paying them and not getting them to do any work. So that will be could be a different situation from business to business. You do need to get some advice there based on the particular circumstances of your business.
Right,
thanks, Andy. And I might just add to that. Sorry, it's Huda from KPMG Law, and I'm obviously not an employment lawyer. But the legal advice you'll receive will also depend on whether or not the particular employee is under an award and so on. So it will impact on whether they could be stood down for a period and then brought back into the workforce. So it's best to get legal advice on that.
Thank you, Huda. Okay, next question. How do we define regular casual? Our business operates a range of venues, including event stadium venues. Staff don't work the same shifts every week. Requirements change due to event schedules and expected attendances. We are inclined to set a floor limit of staff needing to average 2 shifts per week to qualify, but are concerned Fair Work would consider an even lower floor. They seem to rely on a regular and systematic as the benchmark without defining exactly what that means.
Yep. Look, we're expecting some more guidance from the tax office on what they will accept as being a regular and systematic staff member on a casual basis. I expect the ATO will draw heavily on what the Fair Work Act interpretations have turned out to be there in terms of things that have gone to the Commission. So we're all really hoping for a bit more guidance on that from the tax office within the next few days, so that organisations like the person who asked the question can know a bit better where they stand. It's just a really hard one to answer at this stage. I did see a question as well on whether the casual actually had to physically do some work on the 1st of March itself in order to qualify. That wouldn't be the case. They would just need to have been with you continuously since for more than 12 months and have a regular expected work pattern in terms of that regular and systematic requirement. They wouldn't actually have to physically have been paid for the 1st of March itself.
Okay, right. Question 6, there's 2 parts to this one, and I'm not quite sure what the ask is of the second part. But first part is, if we had made a mistake about the classification of the employee as part-time, can we fix it now and still have them be able to claim JobKeeper?
I guess that's a good. If let's say you classify someone as a casual, and they haven't been with you for 12 months, so you declaim for them, and then you have another look at it and go, well, actually, I should have classified them as a so to speak, part-timer, such that I could have claimed for them. Then you'll have to rely on the commissioners to treat the JobKeeper payment you make for them as having been paid at the right time to make you eligible for the subsidy. So if you want to retrospectively treat someone as qualifying, then you'll have to request the Commissioner's discretion to let that happen, because technically you're not entitled to the subsidy unless you've paid the person the $1,500 a fortnight minimum on a fortnightly basis. So the Commissioner would have to accept you paying late and treating that late payment as having been made on time, and then give you the subsidy. So it's a bit of a process to reclassify people after the event.
Okay, right, thank you. All right, 3 more to go. This one's from Karen. If you feel confident in meeting all requirements, do you need to pay this first fortnight this week? Also, is there a template available to send to employees?
Yeah, no templates yet. Again, we're hoping for those ASAP from the tax office. I mean, the tax office has, been handed this at very, very short notice. So, they're working overtime to try and get this program set up from an administrative perspective. The first JobKeeper fortnight ended on Sunday, and technically people were meant to have their first instalment of $1,500 by Sunday in order for employers to qualify for the subsidy. The expectation is that the ATO will allow payments made after Sunday to be classified as having been made on Sunday, so that employers can qualify, even though the law was only passed Wednesday and Thursday last week. But we haven't seen that in writing yet. So if you're confident you will qualify for either from March or from April in terms of your monthly turnover reduction, then be prepared to start paying the money to staff during April so that you can be reimbursed in early May. But the exact process and boundaries there, we're still yet to see from the tax office.
Great, thank you. All right, next one's from Angela. When you say the employee needs to be on books as of the 1st of March 2020, does that mean that they had to be paid for that week? What if the employee is casual but hadn't worked for a couple of weeks, but they were expecting to work in the future?
No, they don't need to have been paid for that week, but you do need to be able to demonstrate that they've been working with you on a regular and systematic basis for more than a year, and that they had a reasonable expectation of getting more work out of you post-March 2020. But they don't actually need to have been paid for working in that week in which the 1st of March fell.
But they do need to have worked for at least 1 year, is that right?
Correct, if they're a casual, yes.
Right, okay, so this
so
employee...
they need to have been with...
Right. So the question on this one was this employee started on the 1st of March 2020. So that probably would make them ineligible, right?
Okay, so if they actually started on the 1st of March but didn't do any work until afterwards, I think some of these points we still need to clarify with the ATO in terms of how they'll apply the rules. The rules are not explicit in terms of all these cases, but if the person hadn't become entitled to be paid anything by doing work on or before the 1st of March, then they may not qualify. I wouldn't treat it as definite that they could qualify.
Great, thank you. All right, last question, and this one's from Alan. I have a restaurant which started in July 2019. We can't compare from March 2019 as we were not open. We have had to temporarily close due to COVID-19. How do I prove a decline in revenue?
Yeah, that's so. We are pretty confident that the Commissioner will come out with an alternative rule for businesses like that. So it may be that you just have to compare March 2020 with a reasonable trading month from July last year onwards. So if you could say October 2019 was an average month, they'll let you compare to October 2019, for example. Now, we haven't seen that in writing from the Commissioner yet, but based on all of the commentary from Treasury about how this is meant to work, you should be reasonably confident that you'll be able to apply an alternative test in terms of measuring that downturn.
Great. Well, that's a wrap on the questions, guys. Thank you very much for that, Andy. I think the bulk of that sat in your bucket. But look, in closing, we understand this is an extremely difficult time for everyone, and I don't think that there's a single business out there that is not struggling in some way, shape, or form. And unfortunately, the travel and hospitality industry have been hit exceptionally hard, given the nature of the economics of what we do. We do understand that we will get out of this, and we're hoping that it will be sooner rather than later. And we also understand that we are all in this together, and no one is left alone. And that's one of the reasons why we really wanted to pull together this webcast series, because we want to make sure that everyone is informed, included on industry topics. And if there's something that we as Open Table can do to help our partners, and even if you're not an Open Table partner, help the industry in a way that's going to give them some help, direction, decision-making, reference points, contacts, networking capabilities, that's what we're here for. And I can't stress how important it is for us to stick together in these times. I know there's going to be a lot of businesses that are facing some very difficult times up ahead, which may include bankruptcy or insolvency. And for those, we wish you a very, very heartfelt best of luck. And I hope that you and your families can get back on your feet if you are facing those trouble moments. But I think in having said that, please make sure that you utilize as many resources as you can to help you make the best decision for your business. And with that in mind, I'd like to also extend out an invitation to anyone here to our next webcast series, which is going to be focusing on a very important issue that we take very seriously as an organisation and as an industry, and that's mental health. We've brought together some very, very high-profile industry personnel that will join us on the next webcast, which will be next week. Please keep an eye out for the invitation. And until then, please stay safe, take care of one another, and all the best to everyone. Thank you for joining us.